So a case challenging the ATF's ban on bump stocks will be distributed to the Supreme Court for their consideration this Friday. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want you to know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, a case challenging the ATF's interpretation of bump stocks as actual machine guns is seeking Supreme Court review and has been redistributed for conference on January 7th. The case we're going to be talking about in this video is Apashian v. Garland. Now, some quick background on this whole issue, how it arose, and how important this case really is, not just for bump stocks, but for other ATF actions as well, which violate our rights to keep and bear arms. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incident in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. This change in definition made possessors of bump stocks subject to a punishment of 10 years in prison and or a fine of $250,000 if they failed to either destroy or to surrender the devices. The plaintiff in this case, Mr. Apashian, purchased a slide-fire bump stock before the ATF's final rule was issued, like many other people did as well. After the ATF's change in interpretation, he filed the lawsuit against them, which is now seeking review from the Supreme Court. In response, the Biden administration filed their brief to the Supreme Court, arguing that the ATF has appropriately interpreted the term machine gun to encompass devices like bump stocks. The three main arguments the Biden administration made to the Supreme Court was that the petitioner has failed to show a likelihood of success, that there is no division in authority warranting Supreme Court review, and that the question of Chevron deference does not need review. After the Biden administration filed their response, the petitioners filed their reply. In their reply, they argued that the Supreme Court should review the case to determine if Chevron can be waived, if Chevron applies to criminal statutes, and they also argued that the case is well suited to address issues of exceptional importance like this. If you're not aware of what Chevron deference refers to, which is a big part of these cases, Chevron deference is a term coined after the landmark case referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of ambiguous statutes must be rational or reasonable. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what the term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency. The interpretation of the definition machine gun does involve criminal penalties, and therefore the argument in this case is that the rule of lenity would direct courts to interpret it in favor of the people, not the ATF. Now, Apashian was originally set to be distributed to the Supreme Court for conference on December 10th of last year. At the conference, the Supreme Court would consider whether or not they wanted to address this issue of ATF overreach. However, while they were waiting to have that conference, the Sixth Circuit issued their ruling in another bump stock case called the GOA v. Garland case. These cases are similar in nature but arose out of different plaintiffs in different circuit courts. The Sixth Circuit en banc panel in reviewing the GOA case was unable to reach a majority opinion and instead issued a rare 8-8 deadlocked opinion. This deadlocked ruling in the Sixth Circuit resulted in no precedential appeal court decision, and by default, the lower court's ruling in favor of the ATF was affirmed. Now, after the Sixth Circuit's 8-8 opinion, the Apashian case, which was set for conference, was then removed from conference schedule by the Supreme Court. This was likely done because of that recent GOA ruling, and subsequently a supplemental brief was then submitted to the Supreme Court on why the Sixth Circuit's deadlock decision indicates even more that this issue is ripe for the Supreme Court's consideration. In response, the plaintiffs in Apashian filed a supplemental brief to the Supreme Court pointing to the GOA case and the inability of even 16 judges to reach a decision. The Apashian plaintiffs are using that Sixth Circuit decision to bolster why the Supreme Court needs to finally resolve this issue. One of the major things that the Biden administration argued heavily in their briefs to the Supreme Court was that the Supreme Court does not need to review this issue because there is no conflict between the lower courts. However, like we just saw in the GOA case, Not even a single panel of judges can decide on what they should do. Instead, they are reaching deadlocked opinions. One big question after the Apashian case was pulled from the conference schedule was if this case Apashian was going to be on hold until the New York State Rifle and Pistol Association decision. However, now we know that that is not going to be the case. Instead, it has been redistributed for conference once again, and the Supreme Court will consider this case on January 7th and will decide what they're going to do with it. So the Supreme Court will get together and decide this Friday what they want to do with this case. Do they want to take it up? Do they want to deny review? Or hold it till further notice? During the same conference this Friday, the Supreme Court will also be considering the PZV New Jersey red flag case. So we may see early this year how aggressive the Supreme Court really wants to be on these Second Amendment issues. Now, a case like Apashian does not just impact the ATF's attack on bump stocks. That is what is directly involved in this case, but this case could also impact other types of ATF actions, like their recent actions against the rare breed FRT trigger, their interpretation of frames and receivers, their proposed rules on pistol braces, and then also their recent attacks on solvent traps and treating them as actually suppressors. A Supreme Court case like this in the Apashian case or the GOA case would go a long way to correcting the type of ATF overreach that they have been engaged in for many years but have gone unchecked. So we will wait until after Friday to see what exactly the Supreme Court does, and when I get any updates, I will definitely let you guys know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Thank you so much to everybody who likes, comments, subscribes, who's hit the notification bell, who shares these videos. You guys are directly impacting this channel, impacting these videos, and helping this channel to grow beyond anything I could have ever anticipated. And any success of this channel, any success that I've had in trying to advocate for our Second Amendment rights, a lot of that is because of you guys. So thank you so much for all of your support. Also, I just want to mention once again that the Gundy's Awards are open. There's currently voting going on in multiple categories in this kind of Second Amendment world. And right now I'm actually nominated for 2 different categories. One of the categories is Breakout Creator of the Year, and then Top 2A Voices of the Year. So if you guys feel like I deserve to win one of those categories, you can click the link down in the details section or in the comment section and vote for me, and you get 15 votes a day. So you can vote every single day. And if you are one of the top voters, you can actually win a trip out to the Gundy's Awards, hang out, shoot some guns, shoot some tanks, and also hang out with me and other content creators. So again, thank you guys for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars. This nation will be maintained by armed scholars.